Again? Again?
Again?
There are some people that I see over and over and over and over. Miss Cambrick. Since 1999, deadly conduct, 99, failure to stop and render aid, 2002, failure to identify as a fugitive from justice. Now let's get into 2000s. 2004, theft. 2004, theft. 2005, felony theft. 2005, theft. 2005, theft. 2006, theft from a person, felony theft from a person. Possession of a controlled substance, 2007, possession of a controlled substance, 2007. In 2008, theft. 2009, possession of a controlled substance, 2010, possession of a controlled substance, possession of a controlled substance, possession of a controlled substance. 2012, theft, assault, theft. 16, 17, 18. Now, 2019, theft, 2020, theft, 2021, theft, 2021, theft, 2021, criminal trespass. 2021, theft. 2022, theft. 2022, criminal trespass. 2022, theft. 22, theft. 22, theft. 24, theft. 23, theft. 23, theft. And now, another.
All right, pause right here. This is where the pattern becomes impossible to ignore. What you're hearing isn't just a rap sheet. It's a decadecile-long cycle of theft, drugs, and repeat contact with the same court. From a legal standpoint, this matters because prior convictions absolutely influence bond conditions, supervision, and sentencing exposure. Judges aren't just reacting to this charge. They're reacting to history. And here's the real question for you watching. At what point does accountability shift from punishment to forced intervention?
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On August 29th, 2024, officers responded to a theft of business at a Walmart in Harris County, Texas. Officers made contact with the complainant, the loss prevention associate, who stated on August 28th he contacted officers about a shoplifting, but no officer responded to take the report at that time. The complainant showed the officer the surveillance video, and the officer observed the defendant select a blue tote, walk towards the automotive section, look around to see if anyone was observing her actions, and select multiple Benzoyl motor oil cords off the shelf and conceal them in the tote. The defendant was then observed walking towards the health and beauty section and exiting through an emergency fire door without attempt to pay for the tote or the concealed oil.
How much the value?
Let me check the OR, Your Honor. It's not in the DIMS.
And I'm guessing because they know it's going to be reduced to a misdemeanor, they just now file it as misdemeanors, Michael, instead of a felony?
I'm sorry, what's the question, Judge?
Do they hence assume intake that it's going to be reduced to a misdemeanor as to why they filed it as a misdemeanor?
You know what, Judge? This has been happening a lot, and I'm not sure why. I think, honestly, a lot of it is negligence into not looking at what their criminal history is before they file the charge. Quite honestly, because I see it a lot, and I don't think there's any policy for it.
And Your Honor, the total is $98.
That line right there, that's a courtroom philosophy statement. What the judge is signaling is a move away from revolving door justice and toward behavioral control through bond conditions, drug testing, GPS monitoring, and restricted movement. Legally, this is still pre-trial, meaning the defendant hasn't been convicted yet. But the court is saying we can't ignore the risk anymore. So, here's something to think about. Is this tough love? Or is this the system finally reacting to years of warning signs?
Amber, I'm going to find that there's probable cause to go forward with the case. I'm now sending you for a drug test. I want to know what, if anything, is in your system, and you're to come right back, and then we will discuss where we go from here. I'm going to put a GPS monitor on you, and I'm forbidding you from going to any store that you have a prior contact with in a theft case. Do you understand? And if I find that you have any contact with any of these stores, I'm gonna make your bond so high, your teeth are gonna fall out. Do you understand?
Sir.
Catch and release days are over. No more catch and release. We are going to get to the bottom of why this continues to happen. And if that means some kind of treatment facility with a dual diagnosis residential program, then hey, but now you're working what? 30 thefts? Stops today. First things first, I'm sending you for a drug test. You must come right back. And if you fail to come back, if you fail to take the drug test, your bond will hit the skyline. You understand? We need to do a deep dive, Alex, into every single store that theft, that all those thefts come from. And just, I mean,
Foster,
I know, if we can just forbid from going to any and all retail stores in Harris County, I mean, just,
Yes, Judge, if you would like, we can create a list.
yeah, I'd like to do a dive into every single theft she's done and
Right here, ma'am.
Yes, Judge.
Oh, have a seat in the dirty box store. Going right that way. Go have a seat over there.
7, Foster.
you're Tristan Foster.
Yes, sir.
Mr. Foster, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On October 1st, 2024, officers conducted a traffic stop for a vehicle with no front license plate in Harris County, Texas. The officers made contact with the defendant, the driver of the vehicle, and observed an odor of marijuana. A search was conducted and officers observed a black plastic bag under the front passenger seat containing marijuana and drug paraphernalia, such as a weight scale, a bong pipe, and multiple small bags. The officers also found marijuana grinder in the trunk of the vehicle. Marijuana was identified based on training experience and had a weight of 65.9 grams.
Mr. Foster, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license?
Upon the traffic stop, I found out that it was suspended.
I want to impart something to you that I am making it a bond condition for you now that you're not to drive any vehicle for any reason. I don't care what your reason is. If I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. I don't care if there's a burning building or Mother Teresa needs to go to church. You get into a car and drive, there's going to be HE double hockey sticks to pay. Do you understand? What do you do for a living, Mr. Foster?
Sir,
What do you do for a living?
I do for a living, landscaping.
We're going to reset your case, give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. After that,
Can I file out for an attorney from the state?
why?
So I don't have money for a lawyer.
How do you know? How do you know?
Well, it's not my first time, dealing with lawyers, and I just don't have that kind of money right now.
2018, unlawful carrying of a weapon. 2019, criminal mischief. 2018, assault of a family member. 2019, assault of a family member. 2021, criminal trespass. 2022, unlawful carrying of a weapon. 22, felony possession of marijuana. And now you've gotten another possession of marijuana. In all of those cases, how many times have you gotten a court-appointed lawyer?
So,
Yeah, right.
Mm.
I want you now to go looking, and I want you to get a full-time job. And I am now making that a condition of your bond as well. The days of you sitting at Xbox, playing Xbox all day, smoking dope all day, doing nothing are over. I am making it a condition of your bond that you get a full. You've got that smirk on you. And I'm going to tell you now, it's not going to go well if you try to play with me. Do you understand?
I don't need to go spend my money when I'm taking care of my family to get a lawyer on a case that, you know what I mean?
No. I want you to go start looking for lawyers.
Okay.
And I want you to start Googling Harris County lawyers. There's a gajillion and one of them. Mr.
Yeah,
Foster.
they calling my line. They sending paper through the mail. Y'all know.
Good. Start calling those and finding one you can afford.
Okay.
You pick up a new case. You start driving. I'm telling you now, I'm going to revoke your bond and I'll make it sky high. Do you understand?
I understand.
You know, I'll tell you this though, Mr. Foster, you look like you have a lot of arrogance to you. If you put that arrogance into working really hard, holy moly, you could command the entire world. I know people who started as a freaking dishwasher at Chick-fil-A and they worked their ass off. Now owns two of them making 400 GER a year. That's hundreds of thousands every month that he's raking in because he put his chutzpah into working and his heart into working his ass off. And now, dude, he's killing it. And people thought he was a joke working at Chick-fil-A. And dude's he's the American dream. That's what it's about. Not this, not what you're trying to sell. Don't. Put your heart, soul into it. You can do anything. That's what makes this place so great.
This way, sir.
So is that pre-trial bond condition?
No, we'll have him sign the no driving affidavit. Hey, Don Lee, you ready?
Sir.
Mr. Kozlowski. Mr. Kozlowski.
Come up, Mr. Kozlowski. You're doing so well. Oh, no, I screwed up. What did you test positive for?
Just from a Sunday night I drank.
Stop. Stop. I mean, what am I supposed to do? You're staying with me? I gotta take you in now. No means no. You know, either you don't care about conditions or you have a problem. But no means no. If I let you go, that means that I'm telling you it's okay. Just like Mr. Galvan over there, you know, we have court orders for a reason. When you don't comply with them, there's only one result that happens. It goes with you. All right. So Don Lee. It's with a K, right?
Yes, sir.
I'm really happy it's not cocaine because that's what I thought it was going to be when they told me that you tested positive. That's what I was. So, the bond's at 5,000 now. I mean, I'll just do 6,001. I'm not gonna, you know. We'll see if he bonds out. If not, then we can talk. But I mean, we're not out for blood. So if he's unable to bond out, then we can talk about something in a couple of days.
He should.
What about it?
I think he's gonna work. He's testing. He's just missing. He's asked to be there like 6 o'clock, 5 o'clock in the morning. He finally got a good job.
What's he doing?
He did. I want to say.
I don't think so.
He's clean.
Don Lee, will you talk to him, see what he's doing, and then let's see what we can do.
Yeah, I'm
But-
afraid that that's all right. Because he really is on track.
Okay, find out what he's doing, then let me know, will you, please?
Mr. Cody Fritter, so he was not sent today to get tested because the conditions were amended.
Yeah, he doesn't have to.
Okay,
There was Monday and Thursday, right?
Tuesday, Thursday.
Oh,
Well, it looks like on,
it's supposed to be Monday, Thursdays, because that's what we always do.
right, on 10/3, they were changed to no drug testing medicine. So I wasn't here today, so I don't know who changed.
Okay, I don't know, maybe I misspoke and said Tuesday instead of Monday.
Double check with Abel.
It's my fault. It's my fault.
Let's blame Abel.
Shush.
The
It's my
judge
fault.
said Tuesday, Thursday.
It's not his fault.
We have you on YouTube.
Come up.
Because what I'm saying is the conditions say nothing about drug testing.
Do me a favor, Mr. Fritter, can you please have a seat real quick? Can we go ahead and knock out this one?
Hey, just give me a second. Let me.
Come on, Ron.
Morning, Mr. Campbell. How's jail?
Very good.
Good. That makes me happy. You know, what I find at least, the worse of an experience you have, the higher likelihood you have of actually, when you get out into the free world, of thinking about consequence, because that's what you want everybody to do. Think before you act, think before you speak, because you never know when it's your last time. All I know now is that you're wanted out of another state. You're wanted out of the state of Arizona, specifically Maricopa County, for manslaughter, 2 counts of aggravated assault and endangerment. Day,
Yes, Judge.
tell me about Mr.
That's all I have so far. I do show a Georgia State ID, which I didn't see at first, but I don't see any history originally. I believe this is only offense, but because of the severity of the offense and with the warrant stating that while there is a $150,000 bond, is that they're requesting no bond until he's in front of a magistrate within their state. And so because of the severity of the offense, and the risk of flight, is that state requests no bond for this defendant.
Is this a 2B?
This is QB, Judge. It was issued out on September 25th, 2024.
Okay. And the bond over there is at 150,000.
150, but they will not permit it to be honored until he goes in front of a magistrate with no court.
Okay. Do you know what the manslaughter is about?
No, I don't have the probable cause affidavit, but if you're looking for specifics, I can request it from the DA's office, but I don't have it at this time. I just know that the charges are valid.
Do you have anything that you'd like to add?
Yes, Judge. Mr. Campbell actually hired an attorney, is known about the investigation, so this was not an instance where he's trying to run. The attorney told him they could take a family vacation. So he was arrested at a connecting flight in Houston with his wife and 3 children. So he wasn't trying to run. He was going on a family vacation. His attorney there told him.
We were on the way to the
family. He doesn't live in Houston.
Be going.
So essentially, he gets arrested in the connecting flight process. He's not from Houston. He is ready, willing, and able to go back to Arizona. He's got his attorney set up there. If he gets out, it's not like he's legitimately gonna stay at a hotel and then the next day get on like a bus, as we talked about the flight problem. And he has a vested interest going back. He's 41 years old. I think he has a license case from like 15 years ago, nothing else. Wife, 3 kids in Arizona. He's got 2 prior children in Georgia, but he has like a family life and a business in Arizona, lives there. So he absolutely wants to get back to Arizona. And with that in mind, we would be requesting a bond here so that he can just go back and turn himself in.
No, Mr. Campbell, I really value my city, and I want to protect everybody I can for as long as I can, because the last thing I want is more death, more destruction. And you're wanted for something where there's a dead body.
Oh, sorry, Judge. It just pulled up just now. So Trey is correct. There was a suspended license, but he also had a prior hit and run and failure to stop and return to scene, which seems aligned with the manslaughter and 2 accidents with the vehicle and the
Is
driver.
that with this case or another
No,
case?
sorry, Judge. This is back in Georgia. So after the license suspension, there are 2 cycles. Hit and run, failure to return to scene. There's also DWI back in 2014.
Wow. Continues to happen.
I don't know what happened to that one though. It just.
You want me to set you a bond? Really?
I had to run the state ID when it popped up on the other side.
Yes, absolutely.
Sir, those cases were like thrown out. I didn't. Whatever he has there, the DWI. I never had a DUI. With the hit and run business, that wasn't it.
How do I know that? Am I supposed to take your word for it?
For that thing, my car was stolen, sir. And then they assumed that,
Oh.
just like how here they're assuming that I'm trying to run from.
No. No one's assuming that you're running. No one's assuming that you're running. All we know is that you are wanted out of Arizona, where there's 2 aggravated assaults and there's a manslaughter, so there's a dead body, right? And you also have priors out of another state where there's alleged DWIs and you running from the scene. So my problem is that I have no idea what the circumstances of the manslaughter are. How do I know you didn't shoot someone? How do I know you didn't run someone over in a car at a parade? And so it would be really just dangerous for me to really give you a bond and just let you go when I don't know how.
This is one of the most powerful and rare moments you'll hear from a judge. When a judge says, "You scare me," that's not emotion. That's judicial risk assessment. With an out-of-state warrant involving manslaughter and aggravated assault, the court legally cannot gamble. No, bond here isn't about punishment. It's about unknown danger. And ask yourself this. If you were responsible for public safety, would you release someone when the facts aren't clear and the stakes are life and death?
Dangerous you are. You know what I mean? That's just, it's logic. As much as I'd like to get you back to Arizona as quick as possible, Mr. Campbell, you scare me. How soon can we get Arizona to come pick him up?
I don't know, Your Honor. I mean, well, for him, because he originally waived the magistrate, I know they've already.
He's waived.
Yes, I believe he waived 2 days ago when he went to.
Great.
Yes, so I believe the notice was already sent out.
Typically, the way it works is once you waive, we give that jurisdiction 2 weeks to come get you. Now, sometimes there are circumstances that they might want an extension for a day or two at the max 3. But by and large, they're pretty good at getting that jurisdiction to come get you within the next 2 weeks. And then we give you a free ride back to Arizona where you can answer to those charges. Now, like he said, they're willing to set you a bond. Now, it's going to be a high bond, but you got to get there first. And me, I just don't feel comfortable giving you a bond. I don't know you. I know you're telling me it's little bunnies jumping in the woods, but I really just don't know you. All I know is that there's a trail of destruction, and I don't want any more. That's it. Do you understand? Okay. So, I'm sorry, Shreya. I can't.
No worries, I just want to make sure there's nothing else you want the judge to know about the bond before we discuss issues.
Now, if you're able to post bond, if you're able to get your family to post a bond in Arizona, then they can release this hold and then we'll let you out. But I don't know if that's going to happen, right? Arizona wants you there before they're going to set you bond, is what they've said. So, but you never know until you try. The worst they can say is no. You have a lawyer, perhaps he can go get you a bond there. Okay?
Thank you, Your Honor.
Good luck, Mr. Campbell. Donnelly.
Yeah, I was
I'm sorry.
I was cut off forever.
I know. I'm sorry. Again. Fritter, come on up. How are you, Mr. Fritter?
I'm okay.
What are we doing?
There were bond conditions that he be tested on Tuesday, Thursday. We came.
It's too close.
Right. So we came Thursday of last week, and they were taken off. So now he doesn't have any bond conditions of testing. That's what.
Okay, so we need to put him back on.
Back on
Okay.
Monday, Thursday. Now.
So what's the matter, Mr. Fritter?
Monday I was supposed to have counseling, so that's why we were doing it Tuesdays.
But the test was no. I will figure it out. I got that.
Mr. Fritter, I still have to drug test you.
Yes, I know.
Okay. If you can show me after a while that you've got it under control, then we can modify it. But for now, I want to test you to make sure that you're not using.
Okay.
That's it.
All right, so we just need you to order.
We'll do the bond. So Monday, Thursday, and then the anger management classes, and that's it. Okay? When was the last time he tested? Thursday?
Thursday.
Okay, we're gonna send you now for one, and then we'll see you next week. We'll set him off to Monday for next
For
week.
Monday?
Yeah.
All right. Thank you.
Mr. Freder, you all right?
Yeah.
Okay. Okay, man. Have fun. Or he said he was using his.
Council, he's going on Monday night.
Okay, done. What?
I also have Mr. Gonzalez Martinez. I'm sorry, not Gonzalez Martinez. Oscar Cruz Hernandez.
In custody on bond.
I'm bond judge.
Okay,
Judge, you ordered him to come as well for testing. He is not here today. I got a call from the mother saying that they were on their way to the hospital. His appearance was required today.
ask him for proof on SFBF tomorrow.
Tomorrow?
You know, Abel, it's not the first time they've taken him to the hospital.
Yeah,
So maybe
he's
they
having-
truly
he is-
are.
He is having issues.
And if he's really going to the hospital, I don't know about this part. Right.
No, I'll
But,
that.
you know, even if they can, like, send them a picture of some kind of proof that he's been admitted or something, you know? She really seems concerned.
Right.
She seems like a good person. But he's done, totally.
Your Honor, Mr. Osborne, I had a PCI agreement worked out back in February. He is a high school student. The phone number I had for him got disconnected. I couldn't reach him, which is why he ended up forfeited. I guess they picked him up where he lives now with his mother in Gregg County. He's a high school student. I'm just saying, like,
You have taken off on me 3 different times, Mr. Osborne. If you think that we are going to give you a PR bond, you are charged with assault, bodily injury. You're facing a year in jail. You had an offer in this case where they were going to dismiss this case, and you have repeatedly taken off, not once, not twice, but thrice. I am not going to give you a PR bond, and we are taking you into custody now. Your bond is now set at $10,003 because of all the times that you have taken off. And I get that you're in high school, but the problem is that you have already taken off 3 times. If I let you go now, what does that tell you? What? It tells you that it's okay for you to do what you're doing and not to hold you accountable. And that's not what we do here. You need to understand that courts are here for a reason. We do court orders for a reason. And when you fail to comply, when you fail to show, there are real world consequences. And I don't know if you have anyone that's going to bond you out. If not, you will be stuck like Chuck with me until this thing is over. And I'm going to tell you now, I'm not into this pleading guilty, time served just to get out, just to ruin your life. I'm not going to let you do that.
we accepted the PCI. The states said they would still do it. We accepted the PCI.
I get it, but I'm not letting him out.
I understand with
I mean, it's 3 times the case. How old is this case? It's a year old, and
you set your bond at 10,000, so you post 1,000 worth of bond.
well, I don't know, because whatever they're going to charge you, I don't know. You're a flight risk. They may charge you more.
Can I ask a question?
Sure.
I don't recall leaving 3 times.
You have a criminal case. You know that you are supposed to keep up with it. There's no out of sight, out of mind. You should have enough wherewithal to say, you know what? I haven't had court.
Oh, you don't do it for yourself. This ain't the place where you ask questions, okay? All right.
You should have enough wherewithal to know, you know what? I have court and I haven't heard in a long time. What's going on? The only reason you are here now is because what happened?
But bonding company's attempting to get the case reinstated and or a new bond set for him. That's it. We wanted to let the court know it was our fault for not notifying him of
I'm
the
not
May
going to
setting.
all of the sword. It's not your
I
fault.
do understand. Yes.
You know, if it was one time, okay, but we have 3 different times. It's unacceptable. Okay.
If I may.
Sure.
He did miss court 3 times, but he missed the first one because I couldn't reach him because the phone number I had was disconnected. I reset it 2 more times to try to get in contact with him. So he didn't purposely miss 3 court dates just because I couldn't, the phone number I had for him.
He knows he has court, Mr. Schofield.
I understand.
You know, behavior has consequences. And now you're going to see that there are serious consequences to it. He goes with you. Guys, I'm not out for blood, but I want him to understand that we mean business. If he is unable to make a bond by tomorrow, then we can talk, and I'm happy to entertain perhaps something tomorrow. I get it that he's in high school, but I want him to understand that we mean business. And if I just let him go now, it's enabling him, and it's not a good thing. But I'm happy perhaps tomorrow, if he's unable to make bond, we can talk about a PR bond tomorrow.
Should we just set it for review for tomorrow?
He's going to come back tomorrow regardless because they'll auto-populate.
Okay.
Because that's what happens when we take someone into custody, they auto-populate for the next day. So we can talk about it tomorrow about, because I'm not going to let him plead guilty just to get out and just to get a conviction on his record. And I'm happy to do this, but I want him to understand that we mean business and we're not playing games. So if he's still here tomorrow, we can talk about doing a PR bond and we'll let him try that. But I'm going to tell you now, he gets an ankle monitor, curfew, and I'm going to drug test him. And I'm going to be his dad. That's it. Okay. All right. Thank you. Today.
Yes, sir, Your Honor. Your Honor, I'm here on Mr. Tempenby Akers. Mr. Akers was advised by you to go take a drug test. It's my understanding from talking to a pretrial services that Mr. Akers had tested positive for THC, alcohol, and
Oh, he tested positive for alcohol. Come up, Mr. Akers.
Akers.
You know, Mr. Akers, I was going to give you the benefit of the doubt as far as meth. Shh. Hey, we need to talk. As far as meth, cocaine, amphetamines, ecstasy, THC, I was going to give you the benefit of the doubt on all that. Because I know, because you tested positive just a couple days ago, that you were probably going to test positive today again. But alcohol is a different story. That doesn't stay in your system 2 days, 3 days. No. And I'm going to tell you now, Mr. Akers, the days of catch and release, done. Guess what happens now?
Thank you, Your Honor.
So I think that at this stage in the game, because we've had so many issues with Mr. Akers, I think probably a TRAS is what we need to do to figure out how we go forward here.
Yes, sir.
But I think that I'm going to do, Mr. Akers, I'm going to do everything in my power to help you. I know that you're not going to like it, and I know that you're going to go kicking and screaming, but I'm going to tell you now, that's it. It's done. And I'm not going to take anything because I want you to get the help that you need. You understand? Okay, goes with you. There's nothing, no justification you can get.